Hey guys. I better not be getting sick again. Okay. Let's see what they're doing. I see a fan. Just a fan. I got hot and I took off my jacket and now I'm cold again. All right, StreamYard. Don't start. Act right. Yay. Our fan's back. Why do they have the fan on? They enter in Massachusetts. They don't need a fan. Oh, wait. Can't you do the fans like in the opposite direction when it's cold and it pushes warm air down? I don't know anything about hot in Florida. Well, except for now. We're having a freak winter storm. No, Judy. Gerald Radford is 2-4. Yeah. So what's the other county I've tried to find? Osceola County's hard. There's another to find documents in any other state. They want you to fill out the FOIA request and pay money. I'm not doing that. What's frozen? I'm frozen. I am frozen. Why am I frozen? Okay, I'm back. I don't know why I froze.
Go right ahead, Mr. Leslie.
Thank you, Your Honor. Welcome back, Dr. Russell. We left off talking about pattern recognition in your pattern recognition methodology. Are there patterns to dog-inflicted wounds from civilian dogs?
Yes.
What are the patterns?
Oh, there are several patterns. There could be just simple abrasions and grouped abrasions. There can be
Can you name the authors of any peer-reviewed studies in pattern methodology?
yes. So the two come to mind right now, and one is written by Demunic, Demunic and et al. And there's another one with Dr. Pollock et al.
And to help our stellar stenographer, Demunic is DemunnyNck. If you could please turn to exhibit number 33 that is in front of you.
Yes,
Let me know when you have that
I have
exhibit.
I have it.
Do you recognize, is this the Demunic peer-reviewed article that you were just referring to?
Yes.
What I'd like you to do, Dr. Russell, is to point out where in this article there is the rooting of the pattern and pattern methodology, recognition methodology that you've been testifying to. Where is it located? And with the court's permission, I'd like you to read the specific sentences and paragraphs where that methodology is rooted in it.
Tell us first, because if it's a whole page, we're not going to do that.
It's not a whole page, Your
So
Honor.
let's just see
Yeah.
where it is.
Okay. On page 298. The second paragraph on the left-hand side. Okay.
Your Honor, it's not going to be reading a whole page, it's just the portions of this. Is that acceptable
So
to
you
the
can read a
court?
portion of that paragraph, Doctor? Because what you're trying to do is convince me, right? And these are
Understood.
in evidence. So could you
Okay.
tell me where it is, please?
Okay. So left-hand
Right, first
column.
paragraph, second paragraph. Where do you
Second
start?
paragraph. So it's part of the second, the third, and the fourth parts. So it says, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower jaw. Usually the mandibular dental arch is narrower and shorter than the maxillar, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed.
And then if you could skip to the next paragraph, because we want to follow the court's direction not to read everything,
Right.
just trying to focus on the key aspects. Is there something in the next paragraph that also supports it?
Okay, yes. Okay, the above features attribute to the characteristics of dog bites.
Can you tell us what that sentence means? And does that sentence have any relation to the concept of pattern recognition?
Yes, it does.
Explain how.
Okay, well, so they're talking, well, first of all, the previous paragraph was talking about the dentition of the dogs and how there's some variation in the dentition. And then this next sentence says the above features attribute to or relate to or are relevant to the characteristics of what the dog bites would look like.
And then as you continue on in that paragraph, again, not reading every sentence, but is there another part of the paragraph that continues over on to the next page that also supports your testimony that this is talking about pattern recognition methodology?
Yes. So it goes on to say that the puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretch lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to each other, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals which are not accompanied by pulling and shaking, nor by the usage of the prominent canines, and with stab wounds caused by sharp instruments.
Does what you just read establish the pattern and the pattern recognition methodology for dog bites?
Objection, the objection sustained asked the question differently.
What do you conclude from the language you just read with regard to patterns and pattern recognition methodology?
Well, I conclude that patterns are important, and they are what I call highly representative, but they call pathognomonic, meaning that there is nothing else that causes those.
Let's focus on the word, people pronounce it differently,
Yeah.
pathognomonic. What does pathognomonic mean in medicine?
Pathognomonic, to me, I believe it means that you can make a diagnosis based on these factors that are present to the exclusion of any other diagnosis because they are so specific.
So we talked about on your direct, and it was raised on cross, the concept of a differential diagnosis, right?
Yes.
When you have pathognomonic features, is it required to even have a differential diagnosis?
Not really,
Why?
because the pathognomonic features mean that you have the entity or the condition that is explained.
Does pathognomonic mean that the features themselves rule out other possibilities?
Yes, that's what I believe it means.
And is that how you interpret what the author is saying in this article?
Yes.
Please proceed lastly to the next 2 paragraphs, and then we can move on to the next study, I believe.
In conclusion, To identify a lesion as a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff abrasions, include a puncture wound and sometimes an avulsion with irregular borders resembling a dental arch print.
And could you please, as the last paragraph will focus on, read what you consider important in the next paragraph?
The shape of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it mean to you when the author says, and will differ whether or not the full dentition was used to produce them?
So what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes,
Is this support for your pattern recognition methodology?
yes,
Is it direct support for the pattern recognition methodology you have applied in this case?
yes.
Is there another article? You mentioned two, you mentioned Munich and Pollock. So let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34. And is this the Pollock, P-O-L-L-A-K, study that you have mentioned multiple times in your testimony and that's in your report?
Yes.
Please, like we just did with the Munich article, please identify the portions of this study that you've testified support your pattern recognition methodology.
Okay.
And let's
Well,
do
start in the
a
beginning.
seriatim from the beginning. Yes,
I'll do it
please.
from the beginning. So the dog's front, so the first paragraph here.
Okay, the summary?
Yeah, it says summary. Yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, arranged in curved lines. There seems to be a word or two missing.
No, you missed a word. That's
I
okay.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds on humans, there's a pattern?
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of keywords when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time, and with the court's permission, to the next section of this article that supports your opinion that there is a pattern to dog bite wounds on humans, and that there's a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2,
And what is the title of that section?
morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically means form,
And could it mean something in addition to form?
form, pattern, appearance, yes.
So with regard to morphology section, please identify the sections, the parts of the article under this section that you believe, that you have concluded support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I'd go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is interposition of textiles in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the deceased?
Yes,
And what clothing specifically was that?
it was a hoodie type sweater.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth.
And keep reading, please.
On the next page,
Yes.
the spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and/or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it direct or indirect support, these studies?
I believe this is direct.
And do you believe it's robust, these studies, or do you believe there's equivocation with regard to pathognomonic features?
No, I think it's robust, and these articles are cited elsewhere.
And are these articles, particularly the Demunic article, is the citation ubiquitous in the medical literature, or is it sporadic? Are there a lot of citations to Demunic in the medical literature, or are there only a few?
There are quite a few.
And do you recall the book that Mr. Brennan showed to you earlier on in the hearing?
Yes.
Does that book cite to Demunic as support for a section in the book?
It does.
Now, there was confusion. You can put those studies to the side for now, Dr. Russell. Thank you. Now, there was some confusion on cross-examination regarding where these articles could be found. Some were looking for them in your CV. I'm sorry, Mr. Brown.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Redirect.
Sure, I will, Your Honor. Where are the references? Well, are the references to these articles in your CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an accurate statement about how you develop your pattern recognition skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay,
And just ask the question, please. Again, this is redirect, it's not cross-examination.
understood. Yes, understood. Thank you. Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of a wound?
No.
Would that be an accurate statement at all about how you develop pattern recognition skills?
No.
And why is that not accurate?
Because pattern recognition skills are again taught in various subjects in medical school. And I actually started even before medical school, but in medical school, they're taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please give some examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break, right, doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Rizzo. This is about you, and so you've heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
No.
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
No.
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
No.
Is that a rational proposition?
I don't believe so.
There was much discussion. Well, let me strike this. You were asked a number of questions about whether your testimony here for this hearing and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So what I would like to do is to have you have Exhibit 35 which is the transcript of the December 12. Do you have that? It's a thick, it's the December 12, 2024. You should have that.
I do.
Okay. And what I would like you to do is to also have available exhibits 35 and 36 and 37, because that's what we're going to do side by side comparisons. So let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
They're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Now, at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to tab 36, pages 1-30, line 13 to 1-31, line 1. Stop at 1-31, line 1. These were questions in response to what you were asked on direct by Mr. Jackson. And I would, with the court's permission, like you to read the question in the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
I was muted that whole time. I was muted that whole time. Are you serious? And I was making very good points too. Darn it. Can you hear me now? I can't wait till I get the good internet. Because I can't see myself. I can see now that my voice is showing up around my little avatar picture. Darn it. Well, you can't see me. How could you tell that I was even trying to talk? Well, I welcomed Anita, for starters. And yeah, there were holes in the sweatshirt they were like snagged holes from like claws and teeth and stuff from the dog's teeth. And what I was saying was, if you wanted to prove that it was that specific dog, DNA would work better because the skin is elastic. So if his arm had stayed still and she bit, and then you took a mold of her mouth. Oh, I was quiet. I was quiet for too long. Okay. If you took a mold of her mouth and she had just bit him in the arm, just like his arm just there, then you could get accurate measurements. But if he's jerking his arm away in like a fight with a dog, that mold isn't going to match up. So that's not going to prove anything. The measurements aren't going to come out right.
Yes.
Dr. Russell, first of all, do you recall in questions on cross the claim by Mr. Brennan, or the statement in his question by Mr. Brennan, that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion? Do you recall those questions?
Yes.
The DNA just showed that there was
Do you
pig
recall-
DNA.
Well, let's go and look exactly at what you said in response to the.
It just showed pig DNA. And my theory, which could be totally wrong, is that the dog could have eaten, you know how they have like pig treats for dogs, like the pig ears and stuff? That could have been from that. Or the dog could have actually eaten some pork or something. And then that's how the pig DNA transferred. But they didn't swab the wounds for DNA. They swabbed the sweatshirt for DNA. That could have been something. He could have eaten pork and got it on himself. I mean, the evidence collection in this trial sucked.
Question that Mr. Brennan raised, that was raised by the judge. If you could turn to Exhibit 36. And if you could read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct citation. I want you to go to, did I say 37? I wanted to say 36. Did I say 36?
You said 36, but you said page 151. You might have meant page 131.
Right. That's what I want to go to, Will. Okay. Bear with me a moment, Your Honor.
Sure.
This is going to be one of only 2 questions in this area.
He is really
You may have
organized.
meant page 130. That's where we started before
I'm
we came to
impressed.
sidebar.
Thank you, Your Honor. What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150. Thank you, Your Honor.
151.
Can you go to page 151 and read the questions from the court, Judge Cannoni, and what your answers were?
Yes, from line 10. The court, question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion? Answer, yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches. Question, do you know what kind of animal? Answer, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty. Very sure, high degree of medical certainty. Question, reasonable degree of medical certainty? Answer, yes, definitely. Question, and okay, and another question.
No, that's
That's it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer-reviewed studies, and I was convinced that I was correct.
And had you looked at, what caused you to go look at the peer-reviewed studies? What were you
yes.
doing?
Well, so I looked at the peer review studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No,
But you were asked to write a report after June of 2024.
correct.
Now let's go to is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is that something that's common or uncommon in the medical community?
That's very common.
I only have a few more questions, Your Honor. I'm just looking at them to conclude. On cross, you were asked about whether you were aware of or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes,
Was that necessary?
no,
Why not?
because there, first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue, is I wouldn't even know who to send it to because I don't know of anybody with such experience.
I am going to, let's assume hypothetically that Mr. Walsh has stated that these injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, excuse me, the wounds to the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern. And so thus couldn't really even make that opinion and, just didn't recognize the features.
In the hypothetical that I just gave you, do the facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree?
It's about time somebody said that. I have been waiting for that for months.
With that statement? Or the conclusion? Would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
Yes.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up until the point, the mention of the taillight.
But what is it that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe, as opposed to, quote, littered, end quote, aspects.
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found on the decedent? Are you aware?
Not on the decedent.
On any aspects of the decedent's clothing?
Yes.
Do you know, from your experience, with regard to dog-inflicted wounds, your many emergency room evaluations and treatments of them, whether, or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that the dogs, some dogs eat treats that have the pig chews and other kinds of chews. And so yes, they do. Some dogs do eat things that contain pig.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm
Why
done.
don't you come to sidebar instead of having
Okay.
discussion across the court?
I like this new lawyer. He's hitting points that should have been hit in the last trial, that the pig could have been from something the dog ate, that he has no other injuries, that people that are hit by a car usually have. All the things that I wanted them to talk about last time. And I do not like the new prosecutor because he's trying to pull fast ones already. His whole cross was way too long because he kept asking the same question over and over again, just rewording it. But Dr. Russell held her own against him. She knew exactly what he was trying to do. I felt bad for her, but she held her own and even told her that it was offensive. I'm sure a doctor has asked her to read in on a case. I wish she had told Brennan, though. I don't know who I would have asked because I'm the expert. I'm the only person. I hope he doesn't
All right,
recross.
so recross examination.
Ugh. Why, Bev? Why? I haven't used my goat.
You need a moment?
I'm holding Mr. Brennan up. I just
That's
want to
okay.
move my stuff, and I'll be ready in a moment.
Okay.
Dr. Russell, Attorney Lisi, pardon me, asked you about Dr. Walsh's statement about the cause of injuries. Do you remember? He just
Yes.
asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unprotected falls due to various reasons are known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes,
The documented changes in color, swelling of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis is a passive accumulation of blood around the eyes secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes. The 1 centimeter laceration of the right upper eyelid, laceration of the anterior right tongue, and abrasion of the anterior and left aspect of the nose are documented, considered nonspecific, and may have occurred through a variety of mechanisms. Do you agree with that?
yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted from impact of hand with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Okay. When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that
I
up.
don't think Brennan knows what pattern recognition means. I think someone needs to explain it to him like he's a kindergartner.
You said individually, none of those wounds could you say to a reasonable degree of medical certainty were caused by a dog. It's only if you looked at them collectively.
Yes,
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
no.
It doesn't tell you if they're all incurred at the same time, does it?
They were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No,
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart, table 2?
that's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing is, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case,
That's
isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim, does it also say examination of the victim?
I don't have it in front of me anymore,
Well,
but
you relied on it, you don't remember
Yes.
this?
I think we have it. We don't have it.
do I have it? Oh, yeah, it's a minute.
Okay.
Okay,
Table 2,
okay.
page 98, examination of the victim. You did not examine the victim, did you?
Table 2.
Yes,
No.
table 2, page 90. And the last part is examination of the,
I examined the photo.
the last part is examination of the dog. You did not examine Chloe, did you?
No,
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
those
She
Again,
wasn't
the
the
purpose of
attending
this article is
physician.
was about the fatal, how to, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what you
shards,
said.
how many shards were in that sweater?
Objection, Your Honor.
So I'm sorry. You said that's what you say, doctor? Is that what?
Yeah,
is that what-
initiation is those wounds.
Okay,
And
let me
that's what-
rephrase that. That was
Mhm.
shattered.
Yes.
Those shards, how many were there? How many
I
Microsoft?
believe there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told
This is you were told by who?
by defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I was told, yes.
Wouldn't it be more prudent to actually look at the criminalistics report and make your own determination objectively and medically rather than regurgitate a point of the defense?
Well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before you offered this opinion. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater, in a fabric, can puncture it, and it can cause an abrasion to skin. Have you done any tests or studies to rule out that the broken taillight that was in the arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those, excuse me, holes. The,
Sharp piece of glass.
especially on multiple sites, the same exact type wound,
Well,
defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
And he's also forgetting that not all of those glass shards were there. A lot of them showed up later. So how did they scratch his arm when they weren't there? Oh my God.
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look.
Remain dormant in the sweater but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions.
Oh my God. And like they were all there. Even though it came out in trial that they weren't all there, I can't believe they're even retrying this case. Because of all of the stuff that has come out, the public knows that all the cops up there are dirty. Between this and the Birchmore case and the Brian Walsh case, everybody knows. So the Brian Walsh case is supposed to have a hearing tomorrow. And like I said, I'll be at the doctor. I don't know if it's going to be live streamed, because the last hearing of his that we watched was not. We got bits and pieces off.
Dr. Russell, when I'm referring to these shards, and I've said glass shards,
He
in
was
Keith's
done.
sweater, a more accurate way to define it would be that these were plastic shards, the plastic covering of the taillight, not glass. Okay?
Okay.
All right. Thank you.
Dr. Russell, you are all set.
We're done?
We're done. You're done. We're not done, but you're done. You can step down, Doctor.
Thank you.
It's like, thank God.
If counsel can if council really can keep your, Mr. Lessie, if council really can keep your minutes to 15 minutes, I'll give you 5 minutes to pull them together, or 10 minutes to pull them together.
Thank you very much, Your
I
Honor.
really
Alright.
can't keep the arguments to 15.
All right, so I'll be back out at 3:15.
All right, please.
Jeez. This was painful to watch. I don't know how that woman sat through that. I would have ended up in jail. Bev would have had to send me to jail because I would have, oh my gosh. Maybe it's a good thing I didn't become a legal nurse consultant. Although the majority of the things a legal nurse consultant does is not testifying. It's just like reviewing charts and stuff for the attorneys. What's the Justin Moore case? I don't know that one. Oh, I gotta go to Belle. Oh, she's not barking to come in. She's just barking. Justin Moore. That's another case up there in that jurisdiction. I don't understand. I'll never understand. And I know I say this and I've asked this of other lawyers and stuff. Why do they let the judge decide? When they make a motion to recuse the judge, why does that motion go to the judge they want recused? It doesn't make any sense to me. Because of course that judge is going to say, no, I don't want to be recused. But if I was Bev, you guys can hear me, right? I'm not muted. If I was Bev, I would not want not even a hint of impropriety. So I would recuse myself. Because what are we all saying right now? That she is on the McAlpert side and she is doing everything she can to railroad Karen Reed. So whether she is or not, that is the reputation she's getting right now. So it's in her best interest. I know you can't see me, but I don't want to turn my camera on because I don't want to crash it. But it is in her best interest to recuse herself because it makes her look bad, whether she is or not. Enrique Delgado? Hang on, I gotta go, Belle. So Bev was on the Brian Walsh case. Oh, yeah, Spiegel. Good Lord, that guy was a... Yeah, that guy was a piece of work. Passes in a way, like die? Yeah. And then he like spazzed out about the reactions that he was getting and everything. Nowadays, man, don't testify in a trial if you can't take the heat, because everything is all over social media now. I'm so glad we didn't have social media when I was school. I was bullied enough without it. I'd be a basket case now. I had enough to overcome without social media. If man, I'd still be in therapy if there had been social media back then when I was in high school. So why is Bev not on the Brian Walsh case anymore? Did she recuse herself, or she, what happened? Did it just get assigned to a different judge, or she let go of it because she had too many other cases, or what? Does anybody know? Because I remember when we watched that hearing, I was like, oh my God, I know that name. This was Cannoni's case. Because all we got to see of that one was like bits and pieces off of a court TV show, because they didn't live stream the whole entire hearing. So I don't know if they're going to stream the one tomorrow or not. But if they do, we'll have to catch it late because I have that doctor's appointment. And then Radford has a pretrial on the 27th, and his trial is supposed to start on the 4th. And that's another one I don't know if it's going to be live streamed, but it's a Florida one, so hopefully it will be. That's the one that I'm really interested in. And the reason why I'm interested in that one is because of the hate crime element. Because just because you don't like a gay person, I'm not saying he's innocent. I'm just saying, if you don't like a gay person, is it automatically a hate crime? Like, he just doesn't like him as a person, has nothing to do with his sexual orientation. You know what I mean? Because when he came out, he shook his hand and was like, well, good for you. You know, you shouldn't have to hide who you are, and it shouldn't matter. But he just didn't like the guy. Like, I would hate for someone to get extra time in jail or whatever, or not be allowed parole, or whatever the extra punishment would be, when that wasn't the reason he shot the guy or pew-pewed the guy, whatever. How many hours are we in now? I have got to learn these rules. I hope I get some more subs, so I need to worry about the rules. I am thinking, since if these trials, I don't know if they're going to be, I know the Jason Chin trial is going to be live streamed. A hearing was live streamed the other day that we watched. Sound was awful. If the sound is awful on the trial, I'm not going to be able to do it, because I couldn't hear hardly anything that was going on in that hearing. But I looked up, it's really hard. This is another thing I was talking about when I was muted a while ago. It's really, really hard to find court cases. Even in Florida, there's some that are super easy and you can find everything. But Jason Chin, all I could find was the actual court docket, and it said that his next court appearance was on the 13th. And it doesn't say trial or hearing or anything. It just says the next appearance is on the 13th. And the judge that is doing his case has other cases on the 13th as well. So I don't think that's his trial. But the way they were talking about jury selection at the last hearing makes me think that the next appearance would be the trial. So I don't know. But I was thinking about streaming the eye drop murder trial because I did not watch that one. And that was Judge Darrow did that trial, the judge from the Darrell Brooks trial. And I didn't see that one. So I was thinking about if there's no real trials going to happen anytime soon, of maybe restreaming that one to watch with y'all. But I don't know. I want to wait first and see if any of these other trials start. I don't know. I'm just ready to get back to, but I get more people watching when I like to.
All right, did council have enough time to pull your thoughts together?
Yes, Your Honor.
Okay. All right, Mr. Brennan, it's your motion, so I will hear you.
I agree with the judge, Mr. Brennan.
Nobody asked you.
I'd like to start with a couple of very important to your consideration. The time 65 federal supplement, second, page 62. It's a 1992 case authored by Judge Gardner. It had to do with a soft science handwriting analysis. It was a very thorough and thoughtful case that talked about soft sciences, methodology, and when there is an absence of methodology. In that case, I'm sure Your Honor is aware, it had to do with a proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science. Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, is not a science. It's not a methodology. It's not medicine. It is a personal aside. A potential expert has to be in a better position to understand and explain to jurors rather than a simple lay person.
She
That means
is.
there has to be some level of methodology, some type of guidance, some type of study so that they can assist the jury in better understanding what they believe their conclusions are. Empirical is not enough because a subjective opinion without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experience as an ME. She treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education. She doesn't have the qualifications. She doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book. She doesn't have a study that teaches her how to. She never took a training. She never took a class. She never got a degree or certificate. She's looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there's nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity, what is the standard, and we still don't know. After all of this testimony, we don't know. In Cromwell versus Rintala, that case had to do with a prosecution expert talking about paint spill. And this is, could not fit more closely to this case. The conviction was overturned because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience. Their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites, a person with their past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or a particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi, pardon?
Rintown.
Thank you. In Rinaldi, direct the court to page 39. And it talks about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Cromwell versus Franceschi, probably saying that wrong as well. But what that quotes is, while training and experience, to which the expert referred, might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based. It can't be compared. It can't be analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what their purpose. When we looked at Exhibit 5, and we actually broke down the wounds, the separate wounds, 5 wounds, the doctor, I believe, concedes any certainty that those were caused by a dog. Her fallback was, when you look at the entire series of wounds, that equals a dog attack. No basis, no reason why we reached that bridge from uncertainty to dog attack, other than just because that can't be because there's no methodology. The risk we have is you have an expert who gets up in a voir dire, teeth marks, would have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3 the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report. And she's changed her. That impliedly concedes that her testify as an expert not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they, later on, without any real changes in information, changes their opinion for whatever reason.
Hi, guys. Am I back? I don't know what's going on.
As an expert not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides information, changes their opinion for whatever reason. They're not constricted because there's no methodology or standard. And so the fact that this witness was allowed to testify at the last trial with opinions she no longer endorses or stands behind, and the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support, and she does not. There is no doubt about one thing, she has no idea. When I walked and invited her to explain to your honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal empirical history dealing with dog injuries in the ER. And when I asked her for wound one, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of the cause, right? The disability. None. She could just fall back on when I look at everything at the top. Same thing with number 2. One. It does the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. No way they can. And if they want to continue that caused the injuries to wound 1 and 2, that and it wasn't the same mechanism. It doesn't take an expert to know are much different than wound number 1. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally different. And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? She would only give us a conclusive answer. It just is. There was nothing about teeth or tension to claim that that was a dog bite and why she changed it from scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could have moved, would have moved, but yet she has no. And she vacillates between this being potentially bites, could be canines on both sides, or maybe there was a 4-point canine in the smaller fraction of number 1 and number 2 in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle. Then we get to wound number 4, equally baseless. Wound number 4 at first wasn't sure if it even had to do with the dog attack. But then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And in wound number 5, again, a 4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim it's a dog bite. Not just that there was no opportunity and that there was no dog that touched her, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence, that didn't know that there were plastic shards in the sleeve of his arm. The fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there is exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the stand and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA, or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the prognosis reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support. This witness has the comfortableness to testify to Your Honor about an account with the DNA was a parallel to getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine.
Darn it. I paused it to say something and it crashed. He's basically, I'm going to back it up because I don't even know if you guys heard the part I heard. He's basically calling her a liar, is what he's doing. $100%. I don't trust any of the evidence that was collected in this case because of this. But he is basically saying that she's lying and she's making this all up. And she's saying stuff in favor of her cause. She doesn't have a cause. She doesn't have, pardon the pun, a dog in this fight. She just saw this case and thought that she could help and volunteered her help. She doesn't have any stake in the outcome of this trial. She wants to help because with her experience, she saw dog bites. This man, I swear. Okay, I went back. I might have gone back too far, but I don't know where it crashed.
With no basis. The reason why that's important, it shows that this witness has the willingness to the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free reign of an opportunity to look at the exhibit and tell us anything she wants to support as a dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding car accidents.
We don't.
She may have been a police officer, she treats injuries at the hospital, she is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even
But
went
she's
to
a
the scene in this
doctor.
case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology, no facts,
Oh my God.
and ignore
How dare
reality
you?
and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, if she proposes to be, would consider the witness statements to try to defect for it and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with any no factual basis, in defiance of actual fact. It's repugnant to the sense of fairness in the this daily She does not have the credentials and qualifications to do that. She didn't even take the basic steps that you'll see in some of the literature of going. They knew, and she tried to fight with every posturing angle that may be important, but she didn't need to do that. I dare say, if she had taken in some of the literature of going to the dog. They knew. We found taken some steps to try to do due diligence. It wouldn't have ended well for her. Perhaps that's why she didn't. That are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA. There is plastic shards in his arm. She has done no due diligence, and she can't describe any methodology because there is none. Right?
All right, Mr.
Danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement, Mr. Brennan, exist? I would like to start my argument and tell you exactly where I'm going to go. I'm going to go to why we're here and what the issue start. What is their faces to answer? Your Honor said I'm just doing it for the logic in the presentation. I'm going to go through that. I'm going to identify case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced, it's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going to go through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology. I'm going to go through and say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. This hearing. The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it. And went through much more of her finding and made that finding. So let's start with the law. Mr. Brennan and I agree on one thing. The Rottola case is relevant. But respectfully, Mr. Brennan went off in a tangent because it's relevant. In determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony? What are to the decedent? I submit that if you ran an artificial intelligence program, you couldn't come up with a more perfect witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Daubert, that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% her favorite, and I don't believe you could find another witness more qualified, and that's the crucial inquiry. What's the second prong of the inquiry? After qualifications, is the methodology reliable? That's the second. That's for cross at trial. But more important, that do we give more weight to? But the focus of this hearing, why are we here? Second prong is the methodology. Mr. Brennan, 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology. Your Honor sat and heard the same thing that all of us heard. She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. The Munich and Pollock. And we walked through with your honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic. This pattern is so by itself rules out anything else. That's the definition of pathognomonic. And that's what another study said with pathognomonic. It's incredible to me that it can be stated that there's no methodology here and that there's no basis for it. It is generally accepted in the medical community. Not coming here to the court and just testifying, it's my subjective empirical statement. Mr. Brennan, and for which he has no support. And that is to say, we got to look at these wound by wound by wound. And he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is the pattern. You look at these all together, it's pattern that matters. And the authors, Pollock and Demuth, the pattern is pathognomonic. You even have to go to other causes, although Dr. Russell, she did, as all doctors do. So it is incorrect that Dr. Russell didn't say, we got to look at these wound by wound. And he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell, resoundingly, she said, you look at these all together, and it's the pattern that matters. And the authors, Pollock and Munich, say that is pathognomonic. Russell said she did because that's what good, thorough. Dr. Russell didn't explicate a methodology. It's incorrect that she didn't explicate. There's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan has had for almost a month, and he didn't respond, interestingly. We cited to the Lobello case, the Brinker case, both of which are dog wound injury cases, not pain cases. I know a little bit about Lobello because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations, including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so there is a dog bite case from the Southern District of New York, a doctor that sees and treats all these, that's reliable. And this was a Daubert challenge, Your Honor. This wasn't an incidental question. The challenge was defendant's motion to preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts it's Daubert, Lanigan. You can satisfy Daubert, the federal, but you also Lanigan, and under Davis, you can have generally accepted in the medical community as well. There's one case. Another dog bite case, we cite Brinker that Mr. Brennan didn't address is a federal court case in Indiana where same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason, which is a good segue now to Massachusetts cases. Mr. Brennan's hypothesis is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog expert. Here was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person, next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case. I've already given you 2, but a firearm examiner in that case. The court said a judge, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the two cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to, that's why we're here. Is her methodology, pattern methodology, she testified to it, and the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense can, when there's opposition to from after his that is required under law in Massachusetts. I also, Your Honor, go to now, but the Commonwealth has papers, I think, further underscore of the on page 7 of the Commonwealth in our papers, the Commonwealth further quote trained emergency room physician opposed the field of kites or claw muscle science A9. What is squared to the injury? Veterinary medical
I'm back. I'm back. Don't leave. The whole thing crashed this time. Even Chrome. I don't understand what is happening. This didn't start happening until after the Lincoln Riley trial. I don't understand. Whoever bought StreamYard and they added features, good features, better stuff, like stuff I like, but apparently it's overpowered the internet that I had, because the internet before, it was sufficient. But I guess whatever they added, I don't know. So now I have to go find the site again. And of course, everybody's streaming it, so I have to find the legit Court TV site. Good Lord, no, we're not starting over. I gotta figure out where he was. Why is that taking so long to load? Jeez, a flip. Okay. I have no.
The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case. I've already given you two. And I'm going to quote for this case, quality of the proffered expert's education, training, experience, read on to determine reliability. All right. So even in situations where courts have repeatedly said, including if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the two I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology. And that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me
Sorry.
that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor has required, a medical doctor that is required under law in Massachusetts. I also, your honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, our papers on page 11, behavior. How does that square with your honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what your honor might do. So in terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now, a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion. And here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it and sustained it and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunick and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis, but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified, as are able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident. And she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied, beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's documented, but I filed a notice to the court regarding my concerns about ARCA witnesses, and the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
All right. So let's set a date for a Daubert hearing. Any idea how long you expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say that the Daubert hearing, you don't mean an evidentiary hearing, you mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
Well, I can't
set
do
it,
it tomorrow.
or, well, then we'll stay now and do that. Are you ready to do that, Mr.
No,
Jackson?
we just
Then-
got this on January 31st.
Okay,
We've not had an opportunity to respond to
just
it.
December 31st, probably,
What did I say?
January.
New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple of weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that 8 trial date.
I understand an injury hearing requires us to bring someone in from out of state.
You know, so what I'm saying is, file your paperwork,
Okay,
all right? We'll set a date for a hearing.
okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them
Okay,
on Mondays or
that's fine.
Fridays for you,
Understood.
thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so,
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all council have that date cleared because it was a trial date at one point in our,
Right.
in our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
on
Then-
all witnesses, not just that you said you're filing.
The only one he's got is for Rick Rainey.
What did you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARCA witnesses at failure to comply with Rule 14. It's not a Daubert hearing,
Okay,
it's compliance with Rule 14.
okay, so that's different.
Yes, I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay,
If that changes my position, I'll notify the defense and the court. If it doesn't, then I'm going to pursue that motion.
okay.
Aaron, maybe be seen briefly at time
Sure.
about scheduling.
What is a Rule 14 hearing? No, they can't exclude the crash daddies. No. Bev likes checking them out. She's not going to exclude them. Did you guys see that video of her checking them out? At least the one guy. I'll have to find that video. Man. The defense needs to do the same with all of the defense. I mean, the defense needs to do the same to all the prosecution expert witnesses. If they're going to challenge all of theirs, that's not fair. I don't know anything about cell phones, but I totally did not understand. Can you guys hear me? Can you guys hear me? Oh, okay. I'm not muted. All right. I don't understand that woman's explanation about why that text was not done at 2:37 or whatever the time was. Her explanation didn't make any sense to me. So his made much more sense to me. And the ARCA guys, they are as expert can be. There is no reason why they should be excluded. Yes, dear. Be right back. Didn't you just go outside? Did you just go outside? Well, yeah, that's why they don't want the ARCA to be witnesses. Because it hurts their case. Those are the witnesses that did actual testing. They're like the real life Mythbusters. Those are the ones that proved that he wasn't hit by a car. Yeah, Trooper Paul and Trooper Proctor. Is Trooper Proctor gonna be a witness this time? And if he is the jury gonna know anything about what happened? Because Lally was the one that tried to get in front of the text messages and stuff last time, and it backfired. Now, is he still employed, or is he still like suspended without pay or whatever? I wouldn't even I have to put him on the stand, don't they? Because he's the lead detective on the case. Oh, good Lord. If I'd been a DA, I would not have even retried this case. It's just a freaking mess. And the sad... Oh, really? And the sad part is...
Clear, the 31st will be oral argument
31st
at 9 a.m.
what?
And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. and February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over, so we don't have what happened with Dr. Russell, such a big gap in between. Okay? All right, we'll see everybody then. Thank you.
Thank you. Point of order, please.
Thank you, everybody.
So it sounded like January 31st and then February 6th and 7th, I think. Man, everything's happening. Well, I say everything's happening, but I get all these dates and I write them down, and then when I go to look for them, they're not there. Either they're not live streamed or the dates have changed or whatever. The only thing that I've been spot on about has been Sarah Boone and Ashley Benefield, because those have been the easiest ones for me to get the dates for, and the dates have always been right. I do my best, y'all. I do my best. Okay, so like I said, there's a Brian Walsh hearing tomorrow. I don't know if it's going to be live streamed, but if it is, we'll do that one when I get home from the doctor tomorrow. But yeah, I'm getting very worried for Karen because I don't know what... You might have to pay extra for it, Judy. Where are you going anyway? So, I don't know what a Rule 14 is. I'm going to have to look that up. Rule 14 discovery. I wonder if that's because they were like sprung on them so fast last time, but they let them testify last time. Discovery obligations. Expected inability to comply with discovery obligations. So, are you flying into Miami? And then going from there? Oh, okay. I'll read it. I'll read it when I gotta go cook dinner first, and then I'll read it. Okay, well, yeah, that makes sense. But it shouldn't matter. I mean, they gave enough information last time to totally explain. I mean, like, they even built a freaking cannon. So the cruise is out of Cape Canaveral? Because Orlando's inland. Man, if my husband could get new tires on my car, I could drive down there and, like, when you come back from the cruise, drive down there and meet you. My husband won't let me go anywhere because I don't have, he just got me brand new tires on the back and I don't have new ones on the front yet. So he won't let me go anywhere. Because I wanted to go to the Boone trial and he wouldn't let me because of the tires on my car. Yeah, and that's not right. I'm sorry, but it's not right. I know why they're doing it. It's not right, though. It's not just about winning. And they shouldn't even... They shouldn't have even brought... After the mistrial, they should have been like, that's it. We're not going to... Because the sad part about them going after her is that there's never going to be any justice for John O'Keefe. That's the sad part. And these people are going to be able to do crap to somebody else like this in the future because that's what these kind of people do. They feel all high and mighty and they run the town. And I live in a small town. I know how small towns work. And I've been a victim of small town politics myself. So it ticks me off to see people get away with stuff like this. That's why I can't use FedEx anymore because my road has been blocked and the county won't do anything about it because the man that they let block the road, his wife works for the county. So doesn't matter that I've lived here for 30 years and worked in both nursing homes in this community and served the community. And my uncle used to be the sheriff of this county, but that doesn't matter. No. It is. But if you have half a brain in your head, you can tell that all of those people lied. I mean, it's not a stretch. And you don't have to be an expert in body language to read the body language of those witnesses. I mean, Jen McCabe, dripped vitriol on that stand. A fifth grader could have told that woman was lying. I mean, come on. I want the behavior panel to analyze her testimony so bad. I have asked them 3 or 4 times. I don't think they're going to do it. They keep doing Karen Reed. And they keep saying her story's fishy. And I keep saying, please look at Jen McCabe's testimony. Please, please, please. The last video they did on her, though, I think Chase actually believes her. Because, they'll, if you guys watch the behavior panel, I don't know if you do or not, but there's 4 of them. Yeah. But, one person will say something, and then when that goes to the next person, they'll be like, oh, yeah, I totally agree with you. Well, they kind of did that. But Chase would, tweak it a little bit. And, it sounded more like he believed her story more than the rest of them did. And I was like, I think Chase believes her, but he didn't want to come right out and say that he didn't agree with the rest of the group. But he acted more like he believed her. But then they made the comment about, well, she said that she needed to go and she got mad because he didn't come out and she needed to go back home because she had to go to the bathroom. Why didn't she just ask to go inside and use their bathroom? I was like, no, she has Crohn's disease. She doesn't want to just use anybody's bathroom. And they made a big deal about that. That might not have been in the last video they did about her. It might have been in one of the other ones about that she bumped into his car. I mean, there was all these things because they didn't know the case. And they were saying all this stuff that didn't matter. Oh, and they were saying, they were saying well, why didn't they go back to the house? Why did they look all over town? Because they Jen McCabe told her, because she was a sister of the person that lived in the house. So Jen McCabe supposedly called back over there and they said that John never went in the house. That's why they didn't go look at the house. Even though Karen says he went in the house, Jen McCabe told her he never went in the house. So that's why they were looking around town for him and why they didn't go back and look at the house. So don't analyze somebody's story when you don't know the whole story. It doesn't work that way. So I want this to be over and done with, and I just want them to be done and find her not guilty, because I feel bad for her. She has 2 chronic illnesses that have expensive treatments, and she's lost her job and her health insurance, and she has all these legal bills now. Her life has been turned upside down. I don't know what I would do in her place. I don't know what I would do. Maybe it's because I'm chronically ill that I feel so bad for her. I don't know why I feel so bad for her, but this just like really tugs at my heartstrings, and I just want to help her somehow, and I can't. And all I can do is just watch and pray and hope that somebody does something right so she can get the justice she deserves. And I feel bad for his family too. I mean, like, people that are all like free Karen Reed are being like mean to his family, and they're victims too. They lost their brother and their son, and they don't need the crap that's getting laid on them either. I mean, it's not their fault that he died, but why they're like buddy with the McAlberts, I don't get that either. And yeah, she acts suspicious right after it happened because she kind of thought that she did it accidentally. And so she acted guilty because she thought she may have done it accidentally. And I think that that's, in her mind, she was kind of gaslit to think that, is what I believe. And that's why the family thinks she did it, because she acted like she did it. It's a very complex situation. So, and the fact that Beverly is the judge is not helping matters. Oh, it's just, the whole thing turns my stomach, and I just feel so bad for everybody involved. So, okay, guys. Well, I gotta go fix dinner and let Belle in because she's out there barking her head off. And I guess I will see you guys tomorrow if that other hearing is live streamed. If not, I don't know. Because the next thing I have on our schedule is Gerald Radford's pretrial on the 27th. But I might find something else. I'm thinking about maybe live streaming whatever once or twice a week, maybe, just to see you guys, talk to you guys. I don't know, maybe some court hearings or something, or some body cam footage or something. So, if you guys have any ideas of stuff we can do just for fun when we don't have a trial going on or something, let me know, and I will let you guys know how the doctor's appointment goes tomorrow. So you guys have a good rest of your evening, and I will see you later. Bye.